there, friends. How are you doing? I hope you're well wherever you are, whatever time it is. Welcome to MoneyWise. And if this is your first time here, MoneyWise is a platform where we help people to create, to grow, and preserve their wealth. Now, today, my agenda is to get answers to some very serious questions that are of really public interest. So I have a representative from the CMA. His name is Abubakar Hassan, and I'm so grateful, Abubakar, that you've made the time to be here this morning. Abubakar is Director Market Oversight at the Capital Markets Authority. And the reason I'm here today is because we've had very many offers and investment opportunities that have come into the market over the years, and a lot of them have actually either gone under or not paid back investors' money. And so I have questions around how do we get our money back? What's the role of the CMA? And many of the questions a lot of you have asked. So thank you so much for joining us, Abubakar.
Thank you, Rina. Thank you for having me.
Yeah, so before we proceed, maybe I want to find out a little bit about you. Who is Abubakar and what do you do at CMA?
Okay. All right, Abubakar is a lawyer by profession. He's a husband. He's a father to two beautiful daughters. And I come from a small community called Bajuni community in Pate Island in Lamu County.
Bajuni?
Yes.
Wow.
Yeah, that's where I come from.
I didn't know that.
Yeah. It's good to know. At least now you know who
I am.
I'm
now
from.
I know.
Marginalized
community.
Yeah.
But in a beautiful part of the country.
Yes, indeed.
Awesome. Before I get into my questions,
Yep.
I want you to watch this clip for a minute.
Okay.
From the time you gave the authority to solicit for funds and to the time that this bank was placed under receivership, what was the period?
CMA does not take responsibility for correctness of the information in the prospectus.
Abubakar,
Yep.
you have said very passionately that CMA does not take responsibility for the correctness of a prospectus. So
Yes.
the prospectus is a document that investors receive. You know, I could be sitting in Murarandi and I'm a villager there and I've invested in a company that's doing a rights issue or a bond. And I receive this glossy document that shows CMA has approved, and you say that CMA does not take responsibility for the contents or the correctness of what is in the prospectus. Can you just help me understand that? Is that fact, first of all?
Yeah. It's not only a statement of fact, but it's a statement of law. You know, as CMA, we discharge our mandate within the applicable law. So that is a statement of law. And during an offering, the regulatory framework which regulate offering is called a Public Offers, Disclosures and Listing Regulations. Regulation 10, and people and your viewers can go look at it, it clearly states that CMA does not take responsibility for the correctness of the information in the prospectus.
Okay.
So that's a statement of law. Because
Yeah.
on the concept of a philosophy called disclosure-based philosophy. So we can regulate, the regulatory approach can either be disclosure-based or merit-based. So and I'll explain that. So the approach which is anchored in law is a disclosure-based regulation or
So
approach.
whether or not those disclosures are correct or factual or true,
Yeah.
the CMA does not take responsibility?
Yes, but someone takes responsibility. That risk is managed, and I can explain.
Please do.
Good. So if you look at that law, first of all, if you want to come to the market, if you want to come to offer your securities to the market, first you need to get a transaction advisor. Okay? Then after that, you need to prepare the information memorandum, which talks about yourself and what you want to do. That information memorandum must be verified, supported by two important advisors, the legal advisor and the financial advisors, and they give a report on the same. Of course, whatever the financial position you've put there, it's audited, and then there's a reporting accountant who checks on that financial position. Then that information, when it comes to CMA, what do we check? The factors we take into consideration is that, does it meet the eligibility and the disclosure requirements prescribed in law? So you look at your document, we see these are the eligibility requirements, have you met? Okay? And then these are the disclosure requirements, have you met? Okay? One of the examples of disclosure requirement is that you need to tell us about yourself, about who owns that company, who governs that company, what is the management of that company, what do you do, how do you make money, what do you want to do with this money you want now, what are the risks involved, how do you manage those risks, what is the prospect of the business. All that should be in the disclosure requirement. So that information, once it is there, and a disclosure-based approach, we approve it to go to the market so that an investor evaluates that investment opportunity and then makes an investment decision. And if an investor is not sophisticated, the CMA ecosystem has provided for licensed investment advisors, stockbrokers and all that, who will advise the investor before he makes that investment decision. And the good thing, if you pass through a licensed entity, they have to risk profile you before they recommend whether this investment is good or not. If they don't do that, it's an offense if they give you unsuitable recommendation. If you go it alone, it is believed that you have read this prospectus and you have evaluated the merits and the risk of that investment, and you have made that investment decision. So the question will be, so what if that information is wrong? Okay, yeah. Because we have approved information based on the information given by the directors, and of course supported by those financial advisors and the legal advice. Yeah. And that is in the law. The people who are responsible for the prospectus, it is not CMA, it is the offerer. That is the directors of the company and those people who consent, give opinion on that information memorandum. So what happens if that information is wrong? Mm-hmm. Are investors vulnerable?
Completely. They lose their money.
They're not. The law gives investor remedies. Yeah, and the investor remedies are in the law and they're prescribed. And the question is whether they are sufficient, adequate or not. One is, if the information is wrong, it is a criminal offense. The directors of that offerer, and together with his advisors, they can be jailed maximum of 10 years. Yeah? Okay. 10 million Kenya shilling, and I think a maximum of 7 years. It's a criminal offense to do that. Two, there's a civil remedy that they are supposed to compensate back the investors the money they have taken through a misleading information memorandum or prospectus. So there's retributive justice where they'll be punished, and there's also restorative justice where the investors affected will get back their money. The question is, how do we enforce or access those investor remedies? So that is where challenges come in, because CMA has to push that, but enforcement is a function of many variables. It's not only the regulator, but also courts. So it has to pass all that process for an investor to realize.
Can we look at one specific example?
Good.
I mean, it's public information, it's out there, and everybody knows about it.
Yes.
And it's the Imperial Bank situation, right?
Good.
So the Imperial Bank situation was such that apparently there were, investigations showed that there were 2 books that were being run by the organization. Yes. They issued a bond, right, for investors to invest in the company for, I think it was 5 years, and then shortly thereafter, in fact, I think it was a bell ringing ceremony, and it was either the next day or the day after that, business shut down, and investors have not received their money.
Okay.
In that instance, you talk about restorative justice.
Yes.
Where are the shareholders now? Who put money, not shareholders, but
investors.
Bondholders, the investors who put money in the bond? Where are they now? Have they received their money back? Have they been restored for the money they put in? What's the situation? Has anybody gone to court, to jail? Where are we with that one?
Okay. So Len, that's a good context. Yeah, I've given the concept, now we contextualize it. Yeah. Then we see how you'll hypothesize on it. So for Imperial Bank, they came to CMA. Of course, there was a transaction advisor. The way of saying the governance structure around the issuance of the security. Transaction advisor, financial advisor, reporting account, and all other players who are supposed to be with the issuer or the offerer. Okay? So the CMA takes that information, they review. I've said you have to check if the information memorandum meets the eligibility requirement. 2 is the disclosure requirement. So one of the eligibility requirements first is, if an entity who wants to issue is regulated or licensed by someone, you need to get a certificate of comfort from that regulator. So you can see there's another layer of protection there. So this is a bank. You need to get certificate of comfort from the central bank because this entity is licensed by central bank. Imperial Bank is not licensed by
CMA.
Capital Markets Authority. It is only one activity which is regulated, which ought to be regulated by CMA when they come to offer their securities to the public. But ordinarily, it is still a bank licensed, supervised by Central Bank of Kenya. Okay?
Yes.
So when they come with all those players who have confirmed the directors that this information is correct, we get one of the eligibility requirements I've told you is to get a comfort from the primary regulator. Is this okay? And to raise capital for a bank, first of all, there are two approvals. You need to meet your capital adequacy thing. You need to get approval internal. And then also, we get a no objection from the central bank if there are any other regulatory concerns. There were no concerns. Okay? So up to there, on the face of it, everything is okay. So CMA reviews it and says this information memorandum meets the disclosure requirement under the disclosure philosophy. Go to the market, let people evaluate you, and make investment decision. What we're doing is within the law. That's what the law says. So they go there, as they're raising, there's a timetable. They're raising the money, blah, blah, blah. And then what we know that is that a fraud is discovered during that process, not before, because the MD of that institution died, and then a fraud is discovered. Okay, when they did their investigation, their inquiry, they found out, yes, there's a problem with the financial position of the bank. Okay, now after that, they reported the matter to central bank, and then central bank put the company under receivership. Okay,
Yeah.
so the money was the process of capital raising had not yet finalized because I believe on 13th it was to be listed. Yeah, and that was the day when it was put under receivership. So what did CMA do? It inquired what happened. Is the information memorandum given to us wrong? And who takes the responsibility for that information? So when an inquiry was done, it was noted that yes, if the director said we came to know about this information after the death of the MD, and this information we had given it to central bank, and we had put under receivership before we came to you. We wanted to come to you, we did not come to you. Okay, so what did CMA do? I told you there is a retributive justice and restorative justice. From retributive justice, we want the people who gave that information in the prospectus to be accountable. Okay, so we gave a show cause to the board of Imperial Bank.
Okay, a show cause, just for people who may not know.
A show cause is an administrative charge. Yeah, once CMA has done an inquiry and believe that there's a reasonable action, there's a reason to believe that action can be taken, you are given a show cause, an administrative charge. It is within the law. No regulator can take action without following the Constitution and the Fair Administration Act.
So you give people an opportunity to explain.
Yes. Why action should not be taken against you. We have done our inquiry. These are the facts. You have violated this law. Please explain why action should not be taken. Okay. Okay. When they receive that.
So who was that to? Was that to the advisors? Was that to the company itself?
To the directors.
Okay.
Because they are the primary responsible for the correctness of the statement in the information in the information memorandum. Okay. So we gave the administrative charge to them. They refused to answer, and then they challenged that administrative charge at the High Court. Okay, so at the High Court level, a decision was made that CMA cannot investigate and enforce at the same time. So it was a structural flaw in how a regulator should work. Okay, we appeal against that decision. at the Court of Appeal. The Court of Appeal agreed with CMA that it can investigate and enforce. Please proceed. They were not happy. They took the decision they challenged the decision to the Supreme Court. The Supreme Court said, you can investigate and enforce, but when you enforce, you need to delegate.
The enforcement.
The enforcement. How to delegate, they did not prescribe.
Okay.
So when we got that decision, they said proceed with enforcement, but delegate. So we delegated. We have a delegation provision in our law. We delegated the enforcement part because investigation was done by management and enforcement is done by the board. The board takes decisions for what happens in the authority. So we said instead of the board sitting, let's delegate to members of the board and non-members of the board. Okay. So we have delegated it to, instead of a board delegating to a subcommittee of the board of CMA, board members of CMA, we've delegated that function
to the committee.
To a committee which composed board members of CMA and independent members. And big names, these former CJ in that membership, big names are there. Okay, just to show that there is that independence, we have delegated that function. Okay, Imperial Bank went to the tribunal now, not the High Court.
The CMA tribunal.
Yes, saying that how we have delegated wrongly. Okay, so the matter is at the court tribunal. It has not yet been heard. Because one of the challenges, once you file something at the tribunal, our decision is automatically stayed. And these guys, when they go to court, they also get orders ex parte. So we just take an action and then it is set aside ex parte. If you go to the High Court,
ex parte
means without even us being heard.
Oh, so you don't even need to be present and they'll get an order.
Yes, they just go there, argue, satisfy the judge that they will suffer irreparably if they don't get a stay order, and they get. At the tribunal, you get an automatic, without even arguing ex parte. You just file and you get...
Which means what happens to the process? It stops completely.
Has stopped.
And you cannot proceed.
Yes, we can't proceed. We have to wait for the tribunal to hear the matter. So we have not even gone to the merits of the case. They're just challenging whether we have the power to investigate and enforce.
Wow.
The Supreme Court said, yes, you can enforce, but you were forced through delegation. We have delegated. They said how you've delegated is we have an issue on how you've delegated your enforcement powers.
In the meantime, what happens to investors?
In the meantime, one of our values as CMA is to observe the rule of law. The law, that is what the law, if there's an order says you cannot do anything, what can we do? However, that is on the retributive justice because we wanted to take an administrative action on if there is evidence that they were involved in the misleading prospectus, and then we can take it to the criminal side. But from the restorative part, you know, one of our enforcement agenda is to follow the money. Yeah, where did the money go? Was it embezzled? What happened to the money of investors? The money, and you're aware when you're doing an offering, the money has to stay with a receiving bank in trust before the process ends. Yes. So the money was, unfortunately, Imperial Bank was also the receiving bank, but they had to open a trust account that you cannot use that money till the process ends. Yeah, the offering process ends. So the money is still there.
Oh,
but the funding was made, the money was still there.
Okay.
And CMA directed Central Bank and KDIC, which had put the company under receivership, to refund.
That's the Kenya Deposit Insurance Corporation.
Yes, to refund the money. So you can see the remedy we have as CMA, we have done what we could within our jurisdiction, within our limits. We have followed it. We have followed with the directors to be accountable for what they did. We followed the money and we saw the money and said the money needs to be returned.
And where is that process now? For the returning of the money? The
returning of the money, now that one is, we need to enforce. That's why I'm saying enforcement of our action is not a function of a CMA alone. For example, when we want to take action on the director, it was also subject to court proceedings. Okay. On this one, that money is not within our control. It is with a sister regulator. We have directed the sister regulator to refund. So, your answer is as well, who is supposed to refund?